Hello everyone, welcome to this video of Tarun IAS. In this video, we will discuss about the Panchayat extension to Scheduled Areas Act 1996. To celebrate the 75 years of progressive India and commemorate the 25th year of enactment of the Panchayat's extension to Scheduled Areas Act 1996, one-day national conference on the PESA was organized. The conference was organized by the Ministry of Panchayati Raj in collaboration with the Ministry of Tribal Affairs and National Institute of Rural Development and Panchayati Raj. Now let's discuss about this Panchayat extension to Scheduled Areas Act 1996. The PESA is a law which is enacted by the Government of India to cover the scheduled areas which are not covered in the 73rd Amendment of Panchayati Raj Act of the Indian Constitution. Let's understand that what is the 73rd Amendment of Panchayati Raj. It has mainly three functions. All three levels of the Panchayati Raj are elected directly by the people. Second, the term is of 5 years. It has 1/3 seats which are reserved for women, and reservations for scheduled caste, scheduled tribes, and OBCs are also provided at all the three levels. Let's talk about that why is this topic in news. The Adivasi self-governance system has disappeared from most of the areas in Jharkhand. During most of the time in history, most of the Adivasis, which were the India's tribal communities, had their own federal governance system. However, the administrative systems during the colonial period and after independence affected the Adivasi governance system to a great extent. The Panchayat extension to scheduled areas, which is also called as the PESA Act 1996, was supposed to uphold the traditional decision-making process. Let's dive into a case study of the tribal governance system of Jharkhand. Jharkhand was carved out of the 28th state of India from the southern part of Bihar in 2000. This part was distinctively different from the northern part of Bihar in terms of geography and social composition. It has 32 different tribes, including 9 particularly vulnerable tribal groups. According to Census of 2001, Santals were 34%, Orang were about 19.6%, Munda tribe was about 14.8%, and Ho, they were about 10.5%, are among the major tribes in terms of numbers. The entire social system was organized into 3 functional levels across major tribal communities in the state. The first one is at the village level. The second at the cluster of 5-6 village levels, and the third at community levels. These decision-making processes were considered people-centric and democratic. Although women were mostly not allowed to participate in such processes, they had their own system of governance which was unlike the caste system, non-hierarchical. Every tribal village had a village council as the basic unit for self-governance. These forums were used to act as the decision-making bodies for all matters which were related to administration, the parliament, and judiciary. The administrative matters were related to maintenance of village commons, such as lands, forests, and water bodies, labor sharing, agricultural activities, religious events, and festivals, etc. The parliamentary matters were related to upholding and interpreting norms, and unwritten laws and traditional values. The judiciary matters were related to managing conflict, disciplinary actions, etc., guided by unwritten norms and values. Then it led to a gradual collapse of the system. After the introduction of the Bihar Panchayat Raj system in 1947, these Adivasi traditional governance system became weak. BPRS was formed, keeping the non-Adivasi areas in view. As a result, due to the non-priority and neglect, the process of the traditional governance system was affected. This was aggravated by industrialization, displacement of Adivasis, and urbanization. The Panchayat extension to scheduled areas, the PESA Act 1996, is to promote local self-governance in rural India. The 73rd Constitutional Amendment was made in 1992. Through this amendment, a 3-tier Panchayati Raj institution was made into a law. However, its application to the scheduled and tribal areas under Article 243M was restricted. After the Bhuria Committee recommendations in 1995, Panchayat Extension to Scheduled Areas Act 1996 came into existence for ensuring tribal self-rule for people living in scheduled areas of India. The PESA conferred the absolute powers to Gram Sabha, whereas state legislature has given an advisory role to ensure the proper functioning of panchayats and Gram Sabhas. The power delegated to Gram Sabha cannot be curtailed by a higher level, and there shall be independence throughout. The PESA is considered to be the backbone of tribal legislation in India. PESA recognizes the traditional system of the decision-making process and stands for the people's self-governance. There are certain powers and functions that have been provided to the Gram Sabhas. Firstly, it's the right to mandatory consultation in land acquisition, resettlement and rehabilitation of displaced persons, then protection of traditional belief, the culture of the tribal communities, furthermore, ownership of minor forest products, resolution of the local disputes, prevention of land alienation, management of village markets, right to control production, distillation and prohibition of liquor, exercise of control over money lending, and any other rights which are involving the scheduled tribes. Now let's talk about the issues which are related to PESA. The state governments are supposed to enact state laws for their scheduled areas in consonance with the national law. This has resulted in the particularly implemented PESA. The partial implementation has worsened self-governance in Adivasi areas like in Jharkhand. Many experts have asserted that PESA did not deliver due to the lack of clarity, legal infirmity, bureaucratic apathy, absence of a political will, resistance to change in the hierarchy of power, and so on. Social audits which were conducted across the state have also pointed out that in reality, different developmental schemes were being approved on paper by Gram Sabha without actually having any meeting for discussion and decision making. Now towards the end, let's talk about that what is the future of PESA. The Panchayat Extension to Scheduled Areas Act, if it is implemented in letter and spirit, will rejuvenate the dying self-governance system in tribal areas. This will also give an opportunity to correct the loopholes in the traditional governance system and make it a more gender-inclusive and democratic space. Thanks for watching this video. This was all about it. And if you have liked this video, so don't forget to like, share and subscribe. And also, don't forget to hit the bell icon to keep yourself notified with the latest videos. Thank you.